Number 17. Yuhu! Saan ka na? Number 17. Esperat.
Sir.
Sige, open cam please.
Wait lang, sir. Inaayos ko lang. Wait. Hindi ko makita. Wait lang. Tara na?
Yeah. So, number 17. Mr. Esperat. For you, what is the definition of law? Blindfold. Huwag kalimutan
Sir,
ng
ano, sir?
blindfold. Ano ang definition ng law?
Law?
Oh,
For me, sir, law. Should I address myself in English, sir?
Sure, why not? Chalk not.
For me, laws are what governs the people and what binds them to have a more peaceful and secured community or country. Yun lang.
Miss Universe.
Wait lang. Okay na?
Relax ka. Bakit kayo natitense? Huwag kayo matense. Ganyan tayo,
Wala
class.
kasi ako makita.
The subject is already stressful. We don't intend to make it mas stressful pa. Trabaho ng teacher, padaliin yung mahirap na subject. So bakit kayo natitense? Relax lang. Chill. Masyado kayong kinakabahan. Okay na, Mr. Esperat, thank you. So, yun, another mechanic ng recitation natin. Kaya mo, unti-unti lang bumabalik sa akin yung mga sinabi ko last time sa A. So, another mechanic ng recitation natin, just because natawag ka sa isang session, does not necessarily mean na magra-round robin ulit, na kailangan tapusin lahat ng nasa class list bago ka matawag ulit. No, hindi ganun ang gagawin natin. Oo, meron na. Oo. Pag natawag ka, it does not, may possibility na matawag ka ulit. Pag natawag ka, may possibility na matawag ka ulit. Oh, meron ako classmate nung ObliCon namin, 3 times na natawag sa isang session. Buti na lang, nasagot niya lahat. Oo, top 15 yun sa batch namin sa board exam. Siya yung pinakamatalino sa amin. Oh, so may possibility na matawag ka sa same session, twice, thrice, depende sa kapalaran mo sa index card. Kung may ginawa kang kasalanan, pinarusahan ka ng Diyos, 3 times ka matatawag, 2 times ka matatawag. So yun, sabi niya basically, yung law, pakisabi kay Miss Dalis, Wimso account, kaya magagalit si Ma'am Sat, dapat Wimso account daw gamitin para pumasok, gusto yung deny entry natin. So basically, law can be defined into, in 3 words lang. Rule of conduct. Rule of action. Rule of conduct, rule of action. Conduct, basically the manner of doing things, the manner of standard kung anong kailangan gawin, anong hindi kailangan gawin. Ganun lang ang simpleng definition ng batas. So for our session today, basically introduction to law tayo. Mag-intro lang tayo kung ano bang meaning ng batas. Then we will proceed to the next topic, which is the general provisions. So, sabi ng book ni De Leon, another naalala ko. I know some of you kumuha ng PDF ng book ni De Leon online. But be careful lang kasi may mga books ni De Leon online for ObliCon na for law school. Yun yung 900 pages. Etong De Leon book ko, 2011 pa to, 465 pages lang to. So, kung gusto nyo maging very diligent sa study nyo, gusto nyo gamitin yung book ng law school, 900 pages yun, go lang, at least may source material kayo. And pwede rin yung gamitin yung book ni Domingo, kasi yung mga first years sa ADSU, Domingo book yung ginagamit nila. Kayong bahala, kasi ang kagandahan sa ObliCon, gaya na sabi ko last time, 1950s pa tong batas na to. And wala pang amendments in regards to ObliCon. So pwede nyong gamitin kahit yung mga 70s, 80s pang book ng law on obligation and contracts kasi hindi pa yan nagbabago. Kaya ito nga, hindi nga ako bumili ng bago. Sa mga subjects ko, ObliCon lang yung hindi ko binila ng bagong book kasi pwedeng gamitin yung luma. Wala namang changes batas yan. Pero pagdating nyo ng law on partnership, corporations and cooperatives, baka ako maging teacher nyo kasi last sem ako yung naging teacher ng mga second years. Nagkaroon kasi ng amendment. Binago yung corporation law natin. So since binago yung corporation law natin, yung book na for that subject, nagbago rin. Hindi nyo na magagamit yung books from the previous years kasi yung amendment sa corporation law was in the year 2019 pa. So since 2019 yun, mga 2020 edition, 2021 edition ng books yung appropriate for the subject. So yun, napunta tayo sa ibang subject. Basically, gaya na sabi natin, the rule of law or the rule of conduct is the basic definition of law. Thus, law in general determines not only the activities of men as rational beings but also the movements or motions of all subjects of all objects of creation, whether animate or inanimate. So basically, yung very definition ng law natin. Bakit? Kasi pag walang batas, by human nature, it will be chaotic, it will be anarchy. Kasi walang nagproprohibit sa'yo You have the absolute freedom to do anything. So, when human nature is considered as a factor, pinasok mo sa equation yan, it will result to anarchy. So, in order to prevent that, in order to prevent absolute freedom, kailangan lagyan mo ng limitations. Kailangan mo lagyan ng limitations. Ang tawag sa limitations sa yun, batas. Law. You need to set boundaries. Kasi pag hindi mo nilagyan ng boundaries yan, by human nature, magkakaroon ng chaos. Magkakaroon ng anarchy. So with that, there are basically just some general divisions sa law into two. Yung una, law in strict legal sense, which is promulgated and enforced by the state. And second, law in the non-legal sense, which is promulgated and which is not promulgated and enforced by the state. Meaning ng promulgated and enforced, hindi ginawa ng ng state, ng estado, which is administered by the government, and hindi niya in-enforce. The first refers to the state law, while the second refers to the divine law, natural law. I know, binasa niya to kasi yung iba sa inyo, 2 a.m. daw. 2 a.m. So, basic, maaga pa yung 2 a.m. sa mga accountancy. Oo, promise. Naalala ko, 1 hour lang tulog ko. Yung ibang, may mga days na 1 hour lang tulog ko ng undergrad pa ako. Chicken yung accountancy niya. Oo, tapos makita mo, mga 7 a.m. classes, lutang pa yun ng mga students. Alam ko nga, kayo yung batch na, na hindi pa na-experience pumasok ng college. Hindi pa sila naka-college. Yun. Makita mo, yung mga 7 a.m. classes, makita mo yung mga lutang na students. Pag may nakita kang lutang na student, mga 7, 8 a.m., for sure accountancy student yan. Wala Ganun talaga Ganun talaga ang course na to. State law, divine law, natural law are comprised in the division rule of action, physical law. So may tinatawag tayong una, divine law, which is from the which is a law that is based on religion and faith. Like sa Then yung source nila, like for example sa Jews, sa Judaism, yung 5 books of Torah, Christianity, yung Roman Catholic, yung Bible for the Muslims, the Quran. So basic definitions lang man to sila Natural law may then be defined as divine inspiration in man in the sense of justice, fairness. Ito, introduction na naman to. Usually, ni-skip to ng mga abogado kasi basically, understandable to sa moral law, physical law, state law. Ito yung pinag-usapan natin ngayon. State law. This is the kind of law, however, which particularly concerns us in the work of state law that is promulgated and enforced by the state. Etc. Concern state law, consideration, concepts of state law. Kasi may klase pa kayo sa Ano oras klase nyo kay Ma'am Sat? 10 a.m. no?
Na-move, sir. 6 to 9 na p.m.
Gabi. 3 hours kay Ma'am Sat.
Opo.
Fire niyo si Ma'am Sat, no?
Opo. Yes, sir.
Huwag nyo galitin si ma'am sa promise. Matakot ang mga students pag ginagalit. Pero pag yan yung funny kay ma'am Sat, magalit yan siya. Then the next meeting nyo sa kanya, okay na yan siya. Makalimutan niya na yung galit niya siya. Mga story niya ba? Tapos takot na takot daw kayo. Uy, sana ako? Hindi naka-record. Hindi yung software ng Google, hindi Google Meet yung ginagamit kong pang-record. Third party software ang ginagamit ko, OBS. May nag-chat kasi. Nag-record ba? Sana tayo ngayon. The term law may be understood into concept in the general abstract sense, in the specific etc. Concept of state law, the mass obligatory rule. Di naman to importante sa board exam. Yun yung sabi sa amin ni Ma'am Sat. We should train you to take the board exam. Yung training namin sa inyo is to take the board exam. Kasi ganun yung naging training. Kasi yung basically yung major difference ng WIMSU and ADSU dati. Sa ADSU, yung training sa accountancy student, ako si Ma'am Sat, pati si Sir Rise, ang training sa amin is for the board exam. Ipasa yung board exam. Meron pa ngayong quote, yung quote na ginagamit ng reviewer namin sa board exam, yung sa Manila kami. CPA now, learn later. CPA now, learn later. Ang importante maging CPA ka ngayon, later ka na matututo. Baba. So, characteristics of law, it is a rule of conduct, it is obligatory, meaning mandatory, kailangan mong sundin. It is promulgated by the legitimate authority. Ito, mga law topics na to mga law school topics na to. It is common observance, necessity. You can answer what does law do, sources of law. Ito, sources of law, tandaan nyo, constitution. Marami tayong naging constitution. Yung sa Malolos Convention, if I remember correctly, yung sa Malolos Convention, yung sa Malolos Convention, yung 1935, yung tawag dito, yung sa Japanese occupation, then yung 1973 Constitution, then yung Freedom Constitution, yung under kay Cory, then yung 1987 Constitution, which is the Constitution that we are using right now. Basically, itong Constitution, it is the mother of all laws. Kapag nagkaroon ng conflict, kakain ka na. Pasensya sa pusa ko, clingy siya ngayon. It is basically the mother of all laws. Meaning, lahat ng batas na kailangang na i-create ng Congress, ng Presidente, lahat dapat nagko-comply. Dapat hindi nagko-conflict sa constitutional law. Bakit? Kasi ang constitutional law, yan yung basis Yan yung foundation of everything. Ngayon, let's go to the sorry class. Now let's go to the next sources of law, legislation. Legislation is the declaration of legal rules by a competent authority. Ito Congress natin to. The Senate and the House of Representatives. Alam ko, pag nagpa-follow kayo ng news, minsan napapakamot na lang kayo ng ulo kung anong nangyayari doon, di ba? Like, tangina na nangyayari to sa kanila. So yan si legislation, sila mismo yung gumagawa ng batas, yung Anti-Money Laundering Act, yung mga ganon, General Banking Laws, mayaan ko. Clingy ka man yan. Yung General Banking Laws, sila yung gumagawa ng mga bills, pero mahirap pag mas mapapahabang usapan natin pag i-discuss ko tong legislation Wait lang, palabas ko ng pusa ko. Chicken. Annyeonghaseyo ulit. Sorry sa pusa ko. Okay, makadiscuss na tayo maayos. So, start tayo sa sa sources of law. Na yung unang sources of law is the Constitution. The Constitution is basically the mother of all laws. Gaya na sabi natin. Lahat ng laws na ginagawa dito sa Pilipinas, whether that's coming from the Congress, yung House and House of Representatives and Senate, whether that's an executive order of the President, or galing man sa Supreme Court, lahat yan dapat nagko-comply with the Constitution. Ngayon, the next source of law is the legislation. Legislation is basically coming from the House of Congress, House of Representatives, and the Senate. Ngayon, the next source of law is the administrative or executive orders, regulations, and rulings. Diba familiar kayo sa executive orders, yung EO naririnig nyo sa news? That is coming from the President, administrative, yung sa mga agencies yan, regulations, etc., etc. The next one is coming from the judicial decisions or jurisprudence, meaning galing sa Supreme Court yan. Kung ano yung nagiging decision ng Supreme Court sa isang case, magiging part siya ng legal system natin. Now, as you can see, legislation saan yan nagagaling? Di ba? Before that, may tatlong branches tayo ng government. The legislative, the executive, and the judiciary. Yang legislation saan nanggagaling? Sa legislative. Yang administrative, executive orders, regulations, and rulings saan nanggagaling? Sa executive branch. Yang judicial decisions or jurisprudence saan nanggagaling? Sa judiciary branch. Ngayon, ito ang tandaan nyo. If there's a conflict between the Constitution and these other laws, sinong mananalo? Ang Constitution. The Constitution will prevail. The Constitution will prevail. Di ba? Kung pag nanonood kayo ng news, yung pinag-usapan nila ngayon is yung anti-terror law, di ba? Pinag-usapan nila, pinagdedebatihan nila, pinag-aaway-aaway nila. Constitutional ba to? Sumusunod ba to sa provisions ng Constitution natin? Particularly with the Bill of Rights? Yan. Kasi pag yung batas is not in compliance with the provisions of the Constitution, wala. Void yan. Illegal yan. Hindi yan susundin. So tandaan nyo, if there's a conflict between a law, other laws, and the Constitution will always prevail. Then another source of law is custom. These are customary acts within the area. So yan. Ruling case of doubt, interpretation of law, organs of social control, laws, confers, or organizations of court, quasi-judicial agencies, classifications of law. Ito, meron tayong two types of meron tayong classifications of law. Yung una, as to its purpose, substantive law, or that portion of the body of the law creating and defining rights and duties which may be either public or private in character. An example of the substantive law is the law on obligation and contracts. Basically, ang substantive law, it provides for the rights and duties of the persons. Pagdating naman sa adjective law, another name sa kanya is remedial or procedural law. It basically prescribes the manner or procedures for which rights may be enforced. So yung substantive law, ito yung nagbibigay ng rights. Ito yung nagbibigay ng duties. Ang adjective law, also known as remedial and or procedural law, ito yung nagbibigay ng procedures on how to enforce the substantive law. Another classification of law is as to subject matter. Dalawa yan, public law and private law. Ang public law is basically law that governs the relationship between the state and the people. Kaya sa public between the state and the people. Another one as to subject matter is the private law. Private law. Etong sa private law, 'di ba sa public law sabi natin between the state and the people. Etong sa private law, from the name itself, between private individuals. Between the private individuals. It regulates the relationship between individuals. Private individuals in their private capacity. Ngayon, sir, if that's the case, may mangi-epal ba dyan ng government? Yes, mangi-epal dyan ng government. In how? The government, papasok yan siya if nagkaroon ng issue. Anong issue yun? When one of the parties or all the parties, wait lang, medyo uncomfortable na. Speakers and when one of the parties, basically, nagkaroon sila ng issue eh. Yung isang party, hindi nag-comply sa kanyang obligation, sa kanyang dapat gawin. O, with that, the other party, nadehado. Aggrieved party tawag sa kanya, nadehado. Sabi niya, paano to? Bakit di mo susundin yung pinag-usapan natin? So in that case, papasok na si government. Anong gagawin ni government? Siya na yung magiging enforcer. He will act as the arbiter. Tawag ito? Arbiter. Siya na yung mag-enforce. O sasabihin niya, uy, ikaw, bakit hindi mo sinusunod yung ano mo? Yung obligation na kailangan mong gawin? Ha? You need to do that. Magiging enforcer na si government sa private right. Now take note, hindi sa party pagdating sa private law. Enforcer lang siya. Because the private law is between the relationship of individuals in their private capacity. Ngayon, yun yung classifications of law. Ngayon, the law on obligation and contracts is part of the civil law. Now take note, di ba gaya na sabi ko, the civil law, the Civil Code of the Philippines was enacted on 1950 pa. November 1950 if I remember correctly. Ngayon, included in private law are the civil law, yung civil code natin, commercial or mercantile law, and civil procedure. Now, civil procedure is that branch of private law which provides for the means by which private rights may be enforced. Sa law school na to. Ngayon, ang law on obligation and contracts, as I have said, is under the civil law. So, yung civil law na yan, yung law on obligation and contracts na yan, is a private law. That is a private law. Ngayon, as provided in Article 1307 of the Civil Code, the law of obligation and contracts is the body of rules which deals with the nature and sources of obligations and the rights and duties arising from agreements and particular contracts. Mamaya pa tayo mag-resit. Yan yung definition ng law on obligations and contracts in accordance with the Civil Code of the Philippines or the new Civil Code of the Philippines kasi before that, we were still following the Spanish Civil Code pero ngayon, new Civil Code of the Philippines ang tawag dyan. So as you can see, body of rules. So parang batas body of rules which deals with the nature and sources of obligations and the rights and duties arising from agreements and particular contracts. Civil Code of Philippines, Civil Code Provisions Obligations, conclusiveness. Ito. Another thing na kailangan nyo tandaan. As in, kailangan nyo ito tandaan. Not only because you're an accountancy student, but also because as a citizen of this republic. Article 3 of the Civil Code. Ignorance of the law excuses no one from compliance therewith. Ignorance of law excuses no one from compliance therewith. Always yung tatandaan. Just because you don't know that the law exists does not excuse you from complying with it. Does not excuse you from being liable for the violation of such law. Hindi nyo pwedeng gamiting defense yan sa korte. Sabi nyo, judge, hindi ko yan alam Hindi ko alam na batas na bawal pala umihi dyan. Hindi, sasabihin ng judge, lol, according to Article 3 of the Civil Code, ignorance of law excuses no one from compliance therewith. You cannot use that as a valid defense. Everyone, therefore, is conclusively presumed to know the law. This presumption is far from reality, of course, but it has been established because of the obligatory force of the law. Kailangan mong sundin Gaya na sabi natin, kapag hindi ka or kapag walang obligatory force ang law, sasabihin natin na depende na lang sa tao kung gusto nilang sundin o hindi. Aba, anarchy yan. You do not set any boundaries. Walang limitations. Human nature will come in. Human nature will always prevail if there are no boundaries. If there are no limitations, it will result to chaos and anarchy. Ngayon, let's start with the provisions of the law on obligation and contract. So basically, yun lang yung Yun lang yung introduction to law. Napakasimple, kahit on your own basahin niyo na. Rule of conduct, rule of action. Ngayon, etong law on obligation and contracts, it came from the book 4 ng civil code natin. Kasi marami yung books eh. Kung gusto yung makakita ng book, pakita ko sa inyo. Ito, book 1 ng civil code. Ito ang law book ng obligation and contract sa law school. Yan yung gano'ng kataba yan. Obligations and contracts pa lang to. Book 4. Agay, tama hulog. So, kung tutusin nyo, ito lang. Gano'ng kataba yun? Ito lang sa atin, no? Siyempre, kasi accountancy students. Hindi pa, kung law school, yun ang gagamitin nyo. Book 4 yun ng civil code natin. Ngayon, sa book 4 na yan, Articles 1156 to 1304, Title 1 yan, for obligations. Ngayon, gaya na sabi ko last time, or nasabi ko ba to last time, for our midterms, ang coverage lang natin is obligation. Obligation lang. Pagdating ng second quarter, doon pa lang tayo magko-contracts. Doon pa lang tayo magko-contracts. So with that, Title 1, Obligations, Chapter 1. Ready ng blindfolds. Number 8. Number 8. Saan ka na number 8? Oy, present ka. Narinig kita kanina. Number 8. Saan ka na? Nakatulog ata to. Aquino, nasaan ka na? Aquino. Yuhu. Chik. Oy, Aquino. Gising. Wala ata siya. Sige, buena mano tayo ngayon. Buena mano. Number 48. Ay, sa baba. Girl. Girl. Blindfold girl.
Ay, wait, sir.
Relax. Ba't kayo natitense? Relax lang. Mas hindi kayo makakasagot pag mag-tense kayo. Oo. Naalala ko pa, nung regular classes pa sa law school, may nahimatay na student. Oo. Tinawag sa recitation. Judge yung nagtawag sa kanya. Pinatawag siya sa recitation, nanginginig, namumutla, nahimatay. Oo, after nun, naging mabait na sa recitation yung judge na yun. So, swerte kami. Oo, nahimatay yung student. So,
Char.
swerte. Naging mabait na sa recitation yung judge. Kung kayo kabahan, relax lang. You're in a safe space,
Wait lang.
charot.
Wait lang, sir.
Lamora, ang ginagawa mo dyan, girl. Sige.
Okay na, sir.
Okay na. But, makinig ka lang.
Opo.
So, Zamora, define obligation.
Sir, an obligation is a juridical necessity to give, to do, or not to do.
Wait lang. Wait lang. Wait lang. Kaya pala wala akong narinig. Iba yung nakaset na.
Ay,
Speaker output
hello?
dito sa classroom. Wait. Pala. Wala narinig kanina. Okay, goods na. Yes, goods na.
Ulitin ka lang. Sir, an obligation is a juridical necessity to give, to do, or not to do.
Isa pa.
No? Ano, sir?
Yun. Ulitin mo.
Isa pa. An obligation is a juridical necessity to give, to do, or not to do.
Isa pa.
Tama din?
Isa pa.
An obligation is a juridical necessity to give, to do, or not to do.
Repeat it 5 times.
An obligation is a juridical necessity to give, to do, or not to do. An obligation is a juridical necessity to give, to do, or not to do. An obligation is a juridical necessity to give, to do, or not to do. An obligation is a juridical necessity to give, to do, or not to do. An obligation is a juridical necessity to give, to do, or not to do.
Last one.
An obligation is a juridical necessity to give, to do, or not to do.
Thank you, Miss Zamora. So, ganun yun. So, ganun yung ginawa sa amin ng ObliCon namin. 10 students, sunod-sunod, tinawag. Yun lang yung tanong. Define obligation. Define obligation. If you can still remember, nung sinabi ko ng orientation natin, without even looking sa book, I was able to say kung ano yung definition ng obligation. Obligation is a juridical necessity to give, to do, or not to do. Obligation is a juridical necessity to give, to do, or not to do. Why? Because it was embedded sa amin. Oo, pag accountancy student ka, automatic HTPM. What is obligation? An obligation is a juridical necessity to give, to do, or not to do. Isa puso't isip mo yan. Isa puso't isip mo yan. Pag accountancy student ka, tinanong ka, anong obligation, di mo nasagot, ala, matay. Lalo na pag accountant rin yung nagtanong sa'yo, ala, matay. La, GG ka. Mapapahiya ka, promise. Why? Because automatic yan. Embedded yan sa isang accountancy student, sa isang accountant, kung ano yung definition ng obligation. Kung ano yung definition ng obligation. Dapat, at least yan, alam mo. Yan yung magiging foundation ng discussion natin for obligation. Yang definition niya. An obligation. Yeah. According to Title 1, Obligations Chapter 1, General Provisions, Article 1156, an obligation is a juridical necessity to give, to do, or not to do. Now, the term obligation is derived from the Latin word obligatio or obligatio, which means tying or binding. Tying or binding. Pinagano sila? Binding yan eh. Dapat sinusunod. So it is a tie or bond recognized by law by virtue of which one is bound in favor of another to render something. Kaya nga, juridical necessity to give, to do, or not to do is bound in favor of another to render something, and this may be consist of giving a thing, doing a certain act, or not doing a certain act. Now take note, Article 1156 gives the definition of obligation in its passive aspect. What do you mean passive aspect, sir? Because it merely stresses the duty under the law of the debtor or obligor. Take note, debtor or obligor, hindi debtor ha, kasi may napapahiya yan minsan, debtor. So, instead na yung maawa ka balik, wala, baka pahiyain to siya ng teacher ba? Kasi debtor. Debtor ha, silent B. Yung debt, D-E-B-T, utang, debt, D-E-B-T, silent B ha. So, debtor ha, huwag kayong mag-debtor. Dito, since safe space to, okay lang. Pero outside of this safe space, papahiya kayo, promise. Debtor, obligor, take note, itong si debtor, itong si obligor, that is the party that is bound. Oo, or sa yung may duty of giving something, of doing something, or not doing something. Sa yung sa yung may obligation na kailangan gawin. Bakit? Kasi malalaman nyo mamaya pagdating sa kung bakit passive. Ngayon, meaning of juridical necessity. As you can see sa definition ng obligation. An obligation is a bala kayo mainis kakarinig ng definition ng obligation. Para rin sa inyo to. An obligation is a juridical necessity to give, to do, or not to do. As you can see, yung first part dyan, juridical necessity. Anong meaning ng juridical necessity? Now, importante itong juridical necessity. Balik tayo sa private law. Di ba sabi natin private law is basically provides the rules of conduct, rules of action between individuals in their private capacity. Ngayon, what if one of those parties hindi nag-comply ng kanilang obligation? Hindi nag-comply ng kanilang obligation. Merong non-compliance. So, paano yan? Ano mangyayari? Kawawa ba? Kawawa na lang ba yung aggrieved party? Hindi, di ba? Gaya na sabi natin, papasok na si government. Magiging arbiter na siya. Magiging enforcer na siya. Pipilitin niya. Uutusan niya. I-enforce niya yung guilty party. Oo. Na, hoy, gawin mo yung obligation mo. Huwag kang paputyo-putyo dyan. Enforcer si government. Now, in that case, kapag nagkaroon ng non-compliance in one of the parties, the aggrieved party can go to the courts to enforce its fulfillment. Mag-file siya ng petition. Sabihin sa korte, which the government, na yung loko-lokong party na yun, hindi kinumply yung kanyang yung kanyang obligation. So, the aggrieved party can go to the government, particularly the courts, to file a petition to enforce the other party na gawin yung kanyang obligation. Kaya ang tawag dyan, juridical necessity. Because if there's a non-compliance, pwede mong takbuhan yung government para mag-insert, para para mag-insert, para siya na yung mag-enforce. Piliting mag-enforce yung loko-lokong party. Kaya yan, juridical necessity. Kasi pag wala yan ang juridical necessity, then, yung loko-lokong party, may choice siya na hindi i-follow yung kanyang obligation. Kasi bakit? Sinong pipilit sa kanya? Wala, di ba? Walang pipilit sa kanya. May choice siya na hindi gawin yung kanyang obligation. So, para gawin niya yung kanyang obligation, kailangan ng juridical necessity. Kailangan ng intervention ng korte. Yun yung juridical necessity. Para magkaroon ng enforcement of the compliance. Enforcement sa compliance with the obligation. So, nature of obligations, civil obligation siya. Obligations which gives to the creditor or obligee. Tandaan nyo, creditor or obligee, siya yung nakaka-receive ng benefit from the performance of the obligation ni obligor or ni debtor. Siya yung nakaka-receive. The obligee or obligee, depende kung anong trip nyo, or the creditor, ito naman, siya yung may right to the performance of the obligation. Siya yung makaka-receive ng benefits Siya yung makaka-demand. Now, there are certain cases na kung saan kapag si debtor, si obligor, yung kailangan mag-perform ng obligation, hindi niya na-comply, then he can be liable for damages. Now, take note, damages. Later, madidiscuss naman natin yan. Marami kasing types of damages You can have the actual, the moral, the liquidating damages, the nominal damages. Kalimutan ko yung ibang terms sila. Pero later, i-discuss rin natin yan. But take note, kapag si debtor obligor, hindi niya kinomply yung kanyang obligation, he can be liable for damages. Now, take note, damages, basically, danyos ang Tagalog yan Danyos. Can be liable for that. Kailan nagkakaroon ng liability for damages? If the obligor or the guilty party has caused injury or harm, and such injury or harm is suffered by the creditor, or the innocent party or the aggrieved party. Kapag nagkaroon ng injury, harm, or loss suffered by the innocent party, then magkakaroon ng damages. Take note, nagkakaroon lang ng damages, ulitin natin, kapag mayroong injury, kapag mayroong loss, or kapag mayroong harm na na-cause sa aggrieved party. Kapag walang ganun, walang damages. Walang damages. So, yun, obligation which gives to the creditor or obligee a right under the law to enforce their performance in courts of justice are known as civil obligations, distinguished sa natural obligations, which the basis of the natural obligations is equity and natural law. So basically sa natural obligations, which sa last part to ng book, ang natural obligations based on equity, based on natural law, and generally wala siyang power of enforcement. Hindi siya pwedeng ma-enforce kasi based on equity na siya. But take note, nakalagay rin dyan, in case there's voluntary fulfillment by the debtor, the latter may not recover what has been delivered or rendered by reason thereof. Example, pag nabigay mo na, hindi mo na pwedeng bawiin. Pwede pala yun, sir. May mga instances kasi na kapag nabigay mo na, pwede mo pang bawiin. Pero pag it falls under the natural obligation, kapag nabigay mo na, hindi mo na pwedeng bawiin. Later on, di-discuss natin yan. Title 3 kasi yan eh. So after ng contracts, short discussion lang pagdating sa natural obligations. If time will permit us. Ngayon, ito. Buena mano. Yung iba, minimemorize na kasi pina-follow sa book yung Pina-follow sa book yung discussion. Number 38. Later ko na pagtripan mga last name nyo pag actual classes na. Oo, pinagtripan ko mga last name ng mga students ko. Pero later on ko na pagtripan yan. Number 38. Sana si Saing. Nagsasaing pa yun ng bigas. Sana si Saing. Iba sa inyo may muta pa. Nawala si Saing. Malas man to siya. Number 48. Nabunot ko lang yun. Oo. Yeah. Prime example. Pwedeng matawag 2 or 3 times. Kung gusto mo mag-call a friend, okay lang. What are the essential blindfold ka muna. Baka nakita mo dyan.
No, grabe.
Blindfold. Bilis.
Naman.
Hindi ko kasalanan. Index card. Wala si Saing eh. Hindi ko yung kasalanan. Okay. Give to me the essential requisites ng obligation. Kung gusto mo mag-call a friend, go lang. Kung may gusto ka pagtripan sa inyo.
Sige. Sino bang? Nag-review ng 2 a.m. Nagbili ako 2 days sir. Pwede ka mag-iit ka kanina sir.
Kaya bahala.
Kung ano mag-iit mo. Si ano sir? Si Singular or si Vinyas. Ali, eto mo ano Ali?
Class sigaw. Sino gusto niyo? Singular si Vinyas?
Sige, sigaw kayo. Singular. Singular na. Go tayo.
Regular.
Regular.
Just po na nag-study civilians.
Wala ko kasi dito.
Labas.
Uy, hindi man to recorded. Uy.
Pa.
Si Tristan. Labas, Tristan.
Uy, wala ka si Tristan.
Halak, blackout pa sa amin. Ako'y na-stress.
Grabe man. Ako na lang ulit, sir.
Blackout.
Blindfold.
Anong tanong, sir?
Uy.
Ay, style mo.
Blindfold.
Ginagawa mo yan sa
Ay,
school.
blindfold. Blindfold ngayon?
Blindfold, ganyan.
Panty lang
Oh.
Nagbablog. Sige, tour na kami sa bahay.
Blindfold mo na ba?
Ay, may house tour pala tayo ngayon.
Oo.
Hala. Hala, bakit di ako na-internet blind?
Uy.
Sige, sir, let's go.
So, anong essential requisites ng obligation?
Wait lang. Ano daw? Ano daw? Essential requisite ng...
Obligation? Brief yan?
Essential requisite ng obligation. Meron ba nun? Sir, dalawa? Dalawa, di ba apat yun? Yun ba yung apat? Ayan. Yung passive, active, prestation or yung object, pati, ano ba yun?
Brief yan?
Sobra ka, damit yan. Parang tanga naman to. Pati yung juridical time or legal time. Parang tanga talaga. Explain ko pa.
Since ikaw
So,
yung follow-up question, please define the four.
Okay. So, para mas maintindihan natin agad, so I'm going to label it based from the example given to the book. So, si passive
Blindfold.
is yung X natin, and yung Y naman yung active natin. Bakit yung tayo? Huwagin mo rin ko. Okay. Wala mag-picture. Parang tanga naman itong mga tao dito, oh. Wala mag-picture.
Alam mo talaga?
So, kasi alam ko yung mga pagkatao nyo. Okay? Talo yan si Sir Habi. Master ha, picture para lahat masaya. Friend lang tayo. Okay. So, I'm going to give like, si X yung passive natin, si Y yung active natin. So, sabihin na natin si X yung engineer. Okay? And si Y yung natin, yung, tama na ba ako, no? Si Y yung nagpapagawa ng bahay. Okay? So, they are buying to each other kasi they have a contract na si engineer nga is gagawa ng bahay para kay Y. So, ngayon, papasok na si prestation. So, si prestation is yung object na napagsunduan ng dalawa. And this agreement will be bind by a legal tie or yung contract natin. So, the contract serve as a juridical tie or yung legal tie natin. However, the passive and active will be changed if the prestation or the object is done or the service is rendered. Kasi ngayon, natapos na yung bahay, babayaran na ito ni X. So, yun lang, sir.
So, sinong ex mo?
Chappy, hello?
Nawala
si sir.
Marami, sir. Marami.
Nawala si sir?
Marami to mention.
Nawala si sir. Okay, class dismiss.
Pangalanan, sir, pangalanan.
Okay na, sir. Okay na yung sagot ni sir yung.
Thank you.
Klase tayo, sir. Thank you.
So, yun.
Perfect na tayo.
Essential requisites ng obligation. Now, ito lang side note ulit. Be careful pag abogado yung abogado yung magiging teacher nyo sa law. Bakit? Kasi pag ipapadefine sa inyo, be careful lang, be cautious kapag definition ang hinihingi sa inyo na magsabi kayo. For example, sir, lalo na yung mga strictang abogado, stricto, Oo, why are you giving example to me? I'm asking for a definition. Be careful lang pag law. Pero since accountancy lang to, chill lang. Chill lang tayo. Kasi, for me, or generally kasi, makikita mo na naintindihan ng tao yung topic if that person can explain it in his or her own words. Kapag bibigyan niya lang siya yung tapos hindi niya ma-explain on their own words, it may be a sign na hindi naintindihan ng tao yung topic. So very good, Mr. or Miss. Anong gusto mo?
Baby.
Ay,
Very good, baby singular. Sabi nung isa, baby daw.
Ala sir, may magselo sir.
Spill.
Nasa klase pa naman siya. Joke lang. Okay sir, continue.
Wala, mami.
LDR kayo.
Start with letter A ba yan?
Oo. Nanay ko yan.
So yun.
Kaya pala, ay,
So yun.
Ala.
So yun. 4 na requisites, meron ng obligation. Passive subject, active subject, object or the prestation, and the juridical or legal tie. Na pagdating sa passive subject, it is also known as ito na yung sasabi natin kanina, 'di ba, yung passive aspect pagdating sa obligor and debtor. Kung saan the person, obligor or debtor, is the person that is bound to the fulfillment of the obligation. This is the person who has the duty. Now, baka yung iba sa inyo inisip, sir, if siya yung mag-a-act sa obligation, bakit siya yung passive subject? Bakit kanina ang sabi, passive aspect? Kasi siya yung mag-a-act, di ba sir? Siya yung may gagawin, so dapat siya yung active. Ganito ang reason yan. Kaya siya passive, kasi take note. Etong si obligor, etong si debtor, siya yung may obligation. Siya yung may kailangan gawin. Obligation to do, to give, obligation to give, to do or not to do. Di ba? Siya yung may obligation. Siya yung kailangan mag-act. Tama. Take note. May choice ba siya na hindi i-follow yung obligation? May choice ba siya na hindi i-follow yung obligation? Wala, di ba? Wala siyang choice. Because he is obliged. May obligatory force yan. He is obliged to follow. He is obliged to comply. Wala siyang choice. Since wala siyang choice, it means passive. Wala siyang choice eh. Kailangan niya gawin. So kaya, passive siya. Passive. Kailangan niyang gawin. Wala siyang choice. Yun yung reason bakit passive. Ngayon, let's go to the active subject. Active subject, which is the creditor or the obligee. This is the person who is entitled to demand the fulfillment of the obligation. Siya yung may right. Siya yung may right. Di ba si obligor, si debtor obligor, siya yung bound to the fulfillment, siya yung may duty. Pagdating kay creditor, pagdating kay obligee, siya yung may right to demand the fulfillment. Siya yung may right. Siya yung entitled to demand, siya yung may right. Now, active subject ang tawag sa kanya. Ngayon, bakit active subject? Kasi, in this case, siya na yung may choice. Siya na yung may choice na kung gusto niyang gawin niya, gawin ni obligor yung kanyang obligation, i-comply niya, or pipiliin na lang ni creditor na, sige, kahit wag mo na yung gawin. Okay lang, goods lang tayo, ox lang. Kaya, active subject ang tawag sa kanya kasi may choice siya eh. May choice siya na wag na lang ipagawa kay obligor, may choice siya na i-demand kay obligor yung fulfillment ng obligation. Because that is the right. Kaya nga sabi dito, this is the person, this is the party na may right. Pagdating kay obligor, pagdating kay debtor, duty. Duty sa kanya. Pagdating kay creditor, pagdating kay obligee, right? May karapatan siya. Yun yung reason bakit si debtor obligor, passive subject, pagdating kay creditor obligee, active subject. Yun yung reason. Now the third requisite, the third essential requisite is the object or prestation. Ano to siya? The subject matter of the obligation. The subject matter of the obligation. The conduct required to be observed by the debtor, it may consist of giving, doing, or not doing. Without the prestation, there is nothing to perform. In bilateral obligation, no, etc. etc. Now take note, yun sa example ni Mr. Singular kanina. Si X bound himself to build a house for Y for 1 million peso. Now, kung tatanungin ko kayo, ano yung object or prestation? Huwag nyong sasabihin na yung bahay. Huwag nyong sasabihin na bahay. Ang sasabihin nyo, to build the house. To build the house. Yun yung object, yun yung prestation. The conduct required to be observed. Hindi ko nga yung literal na object mismo. No, it is the conduct required. Kung ano yung kailangang gawin ni obligor. Kung ano yung kailangang gawin ni obligor. So yung sa example ni Mr. Singular, to build the house. Hindi yung house. To build the house, the conduct required. Yun yung object, yun yung prestation. So do not focus on the thing, but focus on the obligation kung ano yung kailangang gawin. So, lastly, yung essential requisites. A juridical or legal tie, also known as the efficient cause, this is the one that binds or connects the parties to the obligation. The tie in an obligation can easily be determined by knowing the source of the obligation. Okay. Ngayon, let's go back to the example of Mr. Singular. May kontrata si X and Y, di ba? May kontrata si X and Y kung saan si X, being the obligor, is bound to build a house for Y, the creditor. Now, in this case, the juridical or legal tie is the source of the obligation. The source of the obligation. Saan nanggaling yung obligation? Sino nagsabi na may obligation dyan? Doon sa example ni Mr. Singular, yung kontrata nila. Yung kontrata nila. Yun yung source of the obligation. Yung source of the obligation. Sir, can you also give another example na kung saan hindi yung kontrata yung basis ng obligation? Hindi kontrata yung may legal tie? Oo, batas natin. Batas natin. May mga certain provisions o may mga certain laws na kung saan it gives obligation. It provides for the obligation of some parties. Like for example, the obligation of the parent to take care of their child. Kontrata ba yun? Nanggaling bang ang obligation na yun sa kontrata? Hindi, di ba? Nanggaling sa batas. Sabi ng batas, alagaan mong anak mo. It is your obligation as the parent of that child. So yun yung juridical tie. Yun yung legal tie. Yun yung source of the obligation. O, ganun, di ba? Ngayon, let's go to the forms of an obligation. Now, the form of an obligation refers to the manner in which an obligation is manifested or incurred. Manifested or incurred. Paano napapakita? Parang ganun. Ngayon, may mga different forms. Oral man yan, writing, or partly oral or partly in writing. Now, tawag dito, nakalimutan ko. Yun, different forms. Oral, writing, partly oral, partly writing. Oo, pwede kang magkaroon ng obligation kung saan oral lang yan. Oo, like for example, you oblige yourself to give your ballpen sa classmate mo. Orally mo lang ginawa, oy, bes, ibibigay ko sa itong ballpen ko. Yun, may obligation na kayo. May kontrata na kayo. Although it is not in writing, kahit na orally nyo ginawa yan, it is still binding. It is still binding. Now, ang nagpapahirap lang kasi dyan, paano mo mapuprove? Oo, mahirap siyang patunayan na mayroon talagang obligation when it is not in writing. Yun yung basically kahinaan ng oral obligations. Mahirap siyang patunayan. Kasi kung yung writing yan, basahin mo lang, may pirma oh. Oh, I oblige myself to give this ballpen to my classmate. Oh, signed by Signed by the obligor, signed by the obligee. Tapos may witnesses pa kayo para sa ballpen na yan. That is an obligation in the form of writing. Madaling patunayan, pakita mo lang, oh, sabi mo dito, ibibigay mo sa akin ballpen mo. Oh, wala siyang choice. Yeah? Pero, take note, kahit na oral yan, that is still binding. Ngayon, ito, another tandaan nyo. As a general rule, the law does not require any form in obligations arising from contract for their validity or binding force. Ngayon, to take note, isa sa mga iti-take nyo, pag may nakita kayong as a general rule, automatic isipin nyo may exception yan. Kasi hindi yan tatawagin na general rule kapag walang exception. O pag may nakita kayo general rule, automatic isipin nyo may exception yan. So ang sabi dito, as a general rule, the law does not require any form in obligation arising from contracts for their validity or binding cause. General rule. So ibig sabihin, may exception yan. May mga certain forms na kailangan sa ibang contracts na kung saan kailangan may form siya. May specific form na kailangan i-follow. Tawag natin doon, later on, the statute of frauds. The statute of frauds. Pero later, didiscuss naman natin. Anong may example niyan? Yung contracts involving immovable properties. Yan, kailangan nakakontrata yan. In written form yan. Public instrument. Ipanotarize mo. Another, yung mga sales, more than 500 peso. Kailangan may resibo yan. Written form. Ano pa? Yung mga lease na more than 1 year. Written form. Required yan. Statute of frauds tawag dyan. That is an exception to the general rule. Anong general rule? Any forms ng obligation, goods lang. Binding pa rin yan. Pero, may exception. Statute of frauds. There are certain forms na kailangan gawin before that obligation can be binding and valid. Yun. So, tandaan, pag may makita kayong general rule, automatic, may exception yan. So, ito. So, obligation, right, and wrong distinguish. So, konti lang recitation natin ngayon kasi warm up lang naman. So, dinistinguish yung obligation, dinistinguish ang right, dinistinguish silang tatlo basically. So, obligation is the act of performance which the law will enforce. Right, on the other hand, is the power which is under the law to demand from another a wrong. Cause of action, according to its legal meaning, is an act or omission of one party in violation of the legal rights of another. In law, the term injury. Ayun. Take note in law, the term injury is also used to refer to the wrongful violation of the legal right of another. Diba? Gaya na sabi natin, if there's injury, if there's harm, if there's loss na nakos ng isang tao to another, may damages yan. Oo, required yung magbayad ng compensation. Essential elements of legal wrong or injury. There's a legal right in favor of another person, a correlative legal obligation, etc., etc., then an act or omission by the latter in violation of said right. Sir, medyo nahihilo ako. Bakit parati sinasabi dito na there's an act or omission? There's an act or omission. Anong meaning yan, sir? Like, for example, pag may hindi ako ginawa, pwede akong parusahan? Pwede akong magkaroon ng liability? Yes. There are certain instances na kapag wala kang ginawa, GG ka. O, for example, if nakalimutan ko yung particularity nito, yung sa criminal law namin, if a person, basta ito yung general idea nun, nakalimutan ko yung specifics nun. Basta ito yung general idea nun. If a person is in danger, kailangan niya ng tulong, tapos nandoon ka, tapos hindi mo tinulungan, can you be held liable? Yes. Can you be held liable? Yes, because that is an omission on your part. Wala kang ginawa. So kahit wala kang ginawa, since you are required, you are obliged to help that person in need, pero hindi mo tinulungan, that is an omission on your part, and that is punishable by law. Oo, nakalimutan ko lang yung particularities nun, pero meron talaga ganung instances na this person is required to help that person, but this person didn't help, hindi tinulungan, that person can be held liable by the law. So that is an example of an omission na kahit na wala kang ginawa, tapos may record ka palang gawin, hindi mo ginawa, pwede kang parusahan. You can be held liable. So to, kinds of obligation from the viewpoint which may be either personal or real. So, parang hiniwalay lang ito nag-distinguish lang eh. Sa real obligation, which is the obligation to give, take note, di ba? An obligation is a juridical necessity to give, to do, or not to do. Etong sa real obligation, it only talks about the obligation to give. Is that in which the subject matter is a thing which the obligor must deliver to the obligee. Real obligation, X, the seller, binds himself to deliver a piano to Y. Obligation to give. Pagdating sa personal obligation, sa latter half na siya, as another half na siya. Doon sa may kailangan ka ng gawin. Performance na. Hindi na basta bigay-bigay lang. The obligation to do or the obligation not to do. Is that in which the subject matter is an act to be done or not to be done. There are two kinds of personal obligation. Positive personal, negative personal. Sa positive personal, obligation to do or render service. Sa negative, obviously, common sense, sa obligation not to do. Like, may example rin kasi yan na obligation not to do. Like for example, sabihan mo ang kapatid mo na huwag kainin yung pagkain na nasa rep, yung ice cream. That is an obligation not to do on the part of your kapatid na huwag kainin yung iniwan mong ice cream sa rep. Pero in reality, hindi yan nasusunod kasi alam naman natin na putangin na kukunin niya nila at kakainin. Hindi naman nila marinig sa labas. So,
sir, yung mga temporary restraining order, sir, sa negative personal obligation.
Hindi mo pwede lapitan. Mga 50 meters, 50 feet, ganun. Mga TR. Yung mga anti-gag order, hindi ka pwedeng magbigay ng comment sa isang kaso na currently nililitigate, mga ganun. Mga pinagbabawal gawin. Kasi pag yung mga pinagbabawal gawin, ginawa mo, GG ka. You can be held liable. So yun, real obligation, obligation to give, personal obligation, obligation to do or not to do, under sa kanya, positive personal obligation, the obligation to the obligation to do, yung isa naman, yung negative, obligation not to do. Chicken. Nag-mix sila. Mas makakabatong makita niyo nag-shuffle ng nag-shuffle ng index card sa personal. Number 18. 18. Sana si Estrada. Estrada. Wala si Estrada. So malas-malas na lang. Dahil wala yung isa, matatawag yung iba. Minsan yan nakakainis sa mga classmate. Bakit absent ka? Ikaw na yung tatawagin. So number 11 tayo. 11.
Yes, sir.
11. Good morning.
Yes, master.
So number 11. Number 11. Miss Bangay.
Mangay, sir.
Bangay. Sorry. Give to me the sources of obligation.
Cola pencha. Sources. Law. Contracts. Isa. Laki na yung whiskey kagabi. Marimutan ko, sir. Oh my God, pinag-whiskey ko kagabi.
First time nyo siguro narinig yung word na yun. Call a friend?
Yes, sir.
Sino? Magsisira tayo ng friendships ngayon.
Sino-sino nag-study kagabi? Latag yung mga...
Parang Bernadette yun.
Angel. Bernat.
Parang Bernadette atang pangalan.
Hindi, alam ko si Bernard.
Bernadette.
Uy, may mag-volunteer.
Volunteer daw.
Sino?
Si Beliena.
Mag-volunteer.
Sana all.
Si
Sana
Elena.
all.
Sana pag-graded
Sana
na.
all.
Pag-graded na, volunteer rin sana.
Pag ako natawag, mag-volunteer sana.
Miss Daryl.
Siya lang tawagin sa net.
Naka-off ang mic ni girl. Magkamag-anak kayo ni Zamora? Zamora rin ang middle niyo.
Mag-ex, sir.
Hindi, sir.
Wala.
Pagkapatid kami sa ibang nanay at tatay. Start na, sir.
Ikaw, kung gusto mo mag-start na, choice mo. Mag-blindfold, girl. Wait. Sino yung nasa likod mo? May maitim na ano man? Figure?
Sir, last na ko na, sir.
Kapatid niya,
Sige,
dati.
blindfold na. So, biglang magtapik sa likod mo.
Kapatid niya?
Ha? Okdok.
Uy,
Sir,
nakaupo
start
sa...
na ako, sir.
Uy, nakaupo sa mesa.
ObliCon. Start na ako,
Uy,
sir.
nakaupo sa likod mo.
Start na ako, sir.
Ikaw bahala.
Obligation arise from law, contracts, quasi-contracts, law or omissions, punished by law, and quasi-delicts.
Since
Okay na, sir?
Hindi, nag-volunteer ka, so may follow-up question niya.
No.
No.
Ala.
Hanggang sa...
Pwede, back up, sir.
Hindi. Hanggang saan mo makakaya, please define each of them. Hanggang saan mo lang kaya? Ano, call a friend ka rin?
Sir, mag-friend na ako dyan, sir.
So, sinong friend mo?
Si Aliana. Lamora.
Hindi, na-call
Alam
a
mo,
friend.
karma
Hindi
strike
siya na-call a
hard.
friend kanina,
Ang
no?
bilis ng karma.
Hindi siya na-call a friend. Oh,
Ayan na
sorry.
naman.
Hindi ka man na-call a friend
Iba, sir?
kanina. Goods lang. Miss Zamora, tinawag ka ng kapatid mo sa ibang nanay. Hindi ko kasalanan.
Sabi mo,
Ano kasalanan ko sa inyo?
Ang pamilya lang ang magtutulungan.
Ano gawin? Mahal ka na namin. Kaya yan.
Hello, grabe naman.
Hindi ko yan alam, sir. Hindi ko la friend. We love you, Aliana.
Mag-call a friend din daw siya.
Isa lang ang alam ko dyan, sir.
Please define those sources
Law.
of obligation.
Ikaw na yung buong klase.
Yun lang. Law,
In the
sir.
context of being the source of in the context of being the source of the obligation na yung pag-define mo.
When, yung law, sir, when, naalala ko sa book, when they are imposed by law itself, yung contract, oh my gosh. Yung naalala ko sa contract, sir, yung yung meeting of two minds. Hindi, meeting of minds of two persons that, sir, pwede mag-call a friend.
Hindi, ikaw, na-call a friend ka. Hindi mo na pwede pasa.
Madaya man sila.
Mamaya ka na magwara sa GC nyo.
Dito ko mag-oras. Wala, sir, hindi ko tayo alam.
Sige. So, meron tayong 5 sources of obligation. Law, contracts, quasi-contracts, crime or acts or omissions punished by law, also known as torts, and also known as torts, number 5 pala. Quasi-delicts, also known as torts. Ngayon, doon tayo sa law. The law, these are obligations that are imposed by the law themselves. Ibig sabihin, yung batas mismo ang nagbibigay sa'yo ng obligation. Gaya ng sabi natin kanina, the obligation of the parent to support the child. Ito naman, obligation to pay taxes. Pangalawa is yung contracts. When they arise from the stipulation of the parties. Kung ano yung pinagkasunduan ng mga parties sa isang kontrata, yun yung kanilang obligation. Now, ito namang quasi-contract. Sir, unique man yung word na yan. Parang first time, baka yung iba sa inyo, first time narinig yung word na quasi. Basically, itong quasi na to, simplihan natin yung definition sa kanya. Ang meaning lang yan, semi. Parang semi. Partly or partly. Parang quasi-contract, semi or partly kontrata yung kanyang nature. Yun lang yung meaning ng quasi eh. Quasi, semi or partly. So ito, quasi-contract, parang semi-contracto siya. Sabi dito, according to 2142, when they arise from lawful, voluntary, and unilateral acts, which are enforceable to the end that no one shall unjustly enrich or benefit themselves at the expense of another. Pero later on, ma-discuss man dito thoroughly yan. Pero basically, yun yung quasi-contract. Na obligation to return money paid by mistake or which is not due. Another is the crime or acts or omissions punished by law when they arise from civil liability, which is the consequence of criminal offense. The obligation of the thief to return the car stolen by him. The duty of the killer to indemnify the Didiscuss naman to isa-isa. And yung quasi-delicts, ito naman, quasi ulit. Ibig sabihin, kasi di ba itong quasi-contract, before sa kanya is contract. So, quasi-contract, semi-contract. Ito namang sa quasi-delict or torts, para siyang semi-crime. Parang ganun yung niya, nature. Semi-crime. Pero hindi siya as grave as a crime itself. Quasi-delict or torts, when they arise from damage caused to another through an act or omission. As you can see, may omission dito. There being fault or negligence. The difference, take note that there's being fault or negligence but no contractual relation exists between the parties. The obligation of the family, etc., etc. Madidiscuss man to isa-isa. So, the sources of law, classified. The law enumerates 5 sources of obligation. They may be classified as follow. Those emanating from law, yung number 1. Those emanating from private acts. Wait lang. Those emanating from private acts which may be further subdivided into the following. Yung licit acts and yung illicit acts. Now, ito another thing. Side note ulit. Take note, pag accountancy ka or accountant ka, dalawang skills ang kailangan mo. Analytical skill. Oo, yung pagiging magaling sa math, nakakatulong of course, but not necessary. Oo, ako accountant ako, pero bumagsak ako sa isang subject ko sa math, calculus. Sa inyo ata walang calculus sa Wimsu, swerte nyo. Tangina, bumagsak ako calculus. Retake. Pero, hindi necessary na magaling ka sa math para maging accountant ka. Analytical skills ang kailangan. The second one is comprehension. Comprehension. Meaning, yung binabasa mo, dapat naintindihan mo yung meaning. Yung binabasa mo, dapat naintindihan mo yung meaning niyan. So, huwag kayong mahiya kung kailangan nyo ng dictionary para maintindihan yan. Kasi ang importante, naiintindihan mo kung ano yung binabasa mo. Lalo na pagdating sa board exam, pag hindi mo naintindihan kung ano yung hinahanap ng problem, binigay mo yung hindi hinahanap, mali ka. Comprehension, mahalaga yan. So, naalala ko lang kasi, nakita ko tong illicit, tapos naalala ko na sinabi ko rin sa section A. Now, tawag dito, sources classified, nag-enumerate yung 5 sources of obligation, then they may be classified furthermore, those emanating from law, and yung second, those emanating from private acts, which may be further subdivided into the following, yung mga licit acts, meaning yung mga legal, and yung mga illicit acts, which basically yung mga illegal, pinagbabawal. So, under licit acts, yung galing sa contracts, and quasi-contracts, as you can see, legal yan sila. Yung sa mga illicit, yan yung mga punishable by law, yung mga crime, and yung mga quasi-delicts, which, because of there being fault or negligence, nag-cause ka ng damages. So, since nag-cause ka ng damages, ano mangyayari? You need to indemnify. Kailangan mong pagbayaran yung damages na cause mo. Kung nasira mo yung cellphone ng classmate mo, kailangan mong palitan yan. Yeah? Kung kasalanan mo, there being fault or negligence. Now, let's go to Article 1158. Article 1158 provides that obligations derived from law are not presumed. Break muna tayo 5 minutes. Naiihi ako. 5 minutes lang. Okay.
Hi, Ali. Naka-record to, di ba? Sige lang. Ano nangyari sa akin?
Hello. Hi, guys. Wala kayo ibang
Yes.
friend?
Makano pa namin, Ali? Ano ka?
Break na nila kay Daddy. Hi, in one class. Gusto mo break na yung record? Kahit 10 na.
Next meeting talaga
After 5 minutes, 10 na.
Sino ba yung magtawag-tawag din?
Okay. Next meeting, ikaw tawagin ko pag ako natawag.
Sama? Suki na nga sa index card. Kinol a friend ko.
Study ka ba? Sabi ko na, tinapos mo yung Yellow Dragon mo.
Nagpuyat na sila.
Kala mo?
Hoy, nag-review yan.
Nagbasa yan ng Yellow Dragon.
Binasa niya ang buong libro.
Libro ng math.
Shoutout
Ang
muna kay,
yawi.
shoutout muna kay Jonah B. Kasi Jonah B na yung sunod.
Ay, si Jonavi pala yung dapat tinawag niyo. Bakit ako?
Uno si Jola B. Si Giovanni.
Nakita mo na yung pagbalik ni Sir Tan lang. Kapos na ginawa na never mind.
Tatakot na ako sabihin 5 minutes break, tapos mag-10
No.
pa, mag-11 pa tayo.
Sabihan natin.
Pamela, abang-abang ka na, Pamela.
Kaya nga.
Hoy, hindi
Hindi
niyo ako
yata
kaibigan
na-check
ha.
yung
Pero
oras.
kayo, kaibigan ko kayo.
Si Aliana na!
Saan?
Lucky man. Lucky girl.
Sama na ugali niyo. Hindi ko kayo kaibigan. I mean, hindi niyo ako kaibigan, pero kaibigan ko kayo.
Si Kuya Joran, ready na.
Savior yan si Aliana. Savior.
Kuya Joran, ready na matawag.
Pwede din si Al. Di ba Al, no? Si Al na din next.
Talaga?
Boss ako.
Ay, si
Kita, grabe, binasa niyo yung buong
kasi
module.
may jowa.
Si Bern,
Oo. Memorize.
Kapitan kasi, di ba?
Example na, memorize.
Alam na alam. Ako dapat si Jerry
Wait,
Milano
daw.
kasi in love. Or si Nika. Nika May Gonzalez. Saba? Go, Nika.
Go, Nika.
I miss you.
Nika.
Sino
Wala
pa ba
na yan,
tawag?
Tinan.
Pag ako
Uy,
tayo,
si Giselle.
tawagin ko si
Giselle.
Kuya Jorel.
Anong Kuya Jorel ka dyan? Andyan
Giselle.
sila.
Ako si J-Mar. Si J-Mar guys. Si
Giselle.
J-Mar.
Ay, si
Si
Angel
Giselle,
dyan.
tsaka si Giselle.
Ay, wag ako.
Hi, Mami.
Angel, memorize niya buong book.
Ay, ito.
Oo, si Angel.
Si Alrich. Si Alrich.
Pa yan yung study.
Mga lumalamon ng libro.
Oo, yung mga gana.
As, pag ako si Marcom tawagin ko.
Andyan sila.
So, yung mga natawag sa index card, wag na i-call a friend. Okay, puso.
Ay, si Giselle dyan, oh. Ay, lang talaga.
Giselle, tawa-tawa lang.
Ay, ang
Konting-
tawagin ko pala pag mag-ano ako,
Tawa-tawa.
matawag si
Ayan,
Habi.
tawagin natin.
Ay, teacher pala si Habi. Kala class. Ay, sorry.
No! Hala.
Charla.
Sagot ka na. Hala, andyan.
Ay, sorry.
Laser.
안녕하세요.
Hi, master.
10 o'clock na.
Hindi pala dito. Time na daw, sir.
Kayo nag-start. So, sino yung pinagtitipan nyo?
Time na daw, sir. Sabi ni Nita.
Ali.
Hindi talaga no pag hindi pa kayo nagmi-meet as a class sa personal.
Hindi pa sure.
So,
Mga laagan.
Akala mo lang daw, sir.
Mga laagan ng Adventure of the Night.
okay, para yung isang
Si Tan, sir, laagan talaga.
so start na tayo ulit. Para matapos natin to kay 8 something tayo nag-start eh. So to, let's go to Article 1158. Article 1158 provides that obligations derived from law are not presumed. Only those expressly determined in this code or in special laws are demandable and shall be regulated by the precepts of the law which establishes them, and as to what has not been foreseen by the provisions of this book. Ito lang tatandaan nyo kay Article 1158. The law must be very explicit when it gives or provides an obligation. Hindi mo pwedeng i-presume yan. It must not be presumed. Because an obligation that is coming from law, it must be explicit. Anong reason? Simple lang reason. Kasi ang obligation, as we know, kapag may obligation ka, may burden ka. Pahirap ang obligation kasi may kailangan ka gawin eh. Being the passive subject, wala kang choice but to fulfill that obligation, to comply with that obligation. So it is a burden to you. So since it is a burden to you, dapat, sabi dito, pag ang obligation galing sa batas, it must be explicit. Kasi dapat hindi pahirap yan. Hindi dapat unnecessarily pahirap yan. So pag ang batas sinasabi, ulitin lang natin, if an obligation is coming from a law, it must be explicit. Why? Because an obligation in complying therewith is burdensome, pahirap. Yun lang. Basically, yun lang si Article 1158. Now, let's go to Article 1159. Oo, may isa pa tayong tatawagin later. Buena mano. So, Article 1159, obligations arising from contracts have the force of law between the contracting parties and should be complied with good faith. Should be complied with good faith. No, a contract. The above article speaks of contractual obligations or obligations arising from contracts or voluntary agreements. It presupposes that contracts entered into are valid and enforceable. Now, pagdating natin sa contracts, doon, mas in-depth discussion tayo kung kailan natin mako-consider na kung saan ang isang contract is valid, kung saan ang isang contract is enforceable. Ibig sabihin, pwedeng gawin legally according to the law. But take note, in this case, presumption muna na pag may pinag-usapan tayo kontrata, it is valid and enforceable. Now, ito, provided din dito. Basically, yung magiging first article ng discussion natin sa contracts, Article 1305, which provides for the definition of a contract. No? Contract is a meeting of minds between two persons whereby one binds himself with respect to the other to give something or to render some service. No, from that definition alone, alam nyo, mayroon silang stipulations, mayroon silang agreement kung anong gagawin nila within the bounds of the contract. Yeah? Yung gaya example natin kanina, yung si X contracted with Y for which X will build a house for Y in which Y will pay X 1 million pesos in payment, paid na. Yun. Now, binding force, obligation arising from contracts have the force of law between them. Why? Because they have the same binding effect of obligations as imposed by law. Ibig sabihin, di ba? Binding ang law natin. Tapos provided dito, sabi ng batas, yung kontrata na yan, pati yan, may binding force ng law. Bakit? Kasi kailangan maging obligatory yan eh. Kailangan ng obligatory force dyan. Bakit kailangan ulit ng obligatory force? Para may proper compliance. Para may proper compliance. And kapag walang proper compliance with one of the parties, anong gaya sabi din ulit, the government will intervene, for which the government will act as the arbiter. The government will enforce the agreement, will enforce the obligation. This law does not, pero take note, this does not mean that contract is superior to the law. Hindi yun. May binding force na ng law, pero hindi ibig sabihin na superior na siya. Batas pa rin yan eh. Kasi kailangan pa rin mag-comply ng contract kung ano yung sinabi ng batas, kung ano yung standards na sinet ng batas. For example, yung pinag-usapan natin kanina, di ba? Yung forms of obligation. O pag sinabi yung kontrata, kailangan ganito yung form. Kailangan sundin yun. Para maging valid and enforceable. Now, as a source of enforceable obligation, contract must be valid and it cannot be valid if it is against the law. O, ito. Okay. Isa rin to sa mga kailangan tandaan ng mga accountancy students. Kailan nagiging valid ang isang kontrata? Kailan nagiging valid ang isang something? Parang ganun. Ganun yung general idea nun. Requirements of a valid contract. Hindi siya valid if it is contrary to law, morals, good customs, public order, o public policy. Yang phrase na yan, o yung sentence na yan, ilang beses yun maririnig throughout your college life, lalo na sa mga law subjects nyo. Kasi ilang beses yan uulitin. Valid siya, isa yun sa mga sentence na parating na uulit. It is only considered to be valid if it is not against law, public order, law, ano tawag ito? Law, morals, good customs, public order, public policy. May shortcut kami tawag dyan. Lamok PAPS. Lamok PAPS. Ano yung lamok? Yung LA, la, mok, morals. Yung OK, customs, PAPS, public order and public policy. Yan yung shortcut namin dyan. As long as it is not contrary to lamok PAPS, it is valid. Oh, it is valid. Ngayon, if it is contrary to lamok PAPS, then it is not valid. Ganun lang kasimple yung analogy niyan. Now, in the eyes of law, ang tawag natin sa contract na hindi valid is basically void. Oh, which is later ma-discuss natin sa Title 2 sa contracts. Pero tawag natin diyan is void contract. Kapag it is against or it is contrary to lamok PAPS, then it is a void contract. And a void contract means that as if it did not exist in the first place. Parang wala lang yan. Kasi nga void nothing yan. Consequently, no obligation shall arise. A contract may be valid but cannot be enforced. This is true in the case of unenforceable contract. Pero later on, madidiscussin natin yan. Ngayon ito, good faith. Isa pa yun sa parating yung maririnig. Good faith, good faith, good faith, good faith, good faith. Good faith, good faith, good faith. So obligation, marami yan. Basically, sa mga law subjects, marami yan. Good faith, good faith, good faith. Now, compliance in good faith means compliance or performance in accordance with the stipulations or terms of the contract or agreement. Na itong compliance na yun na ginawa mo sa stipulations, sa agreement, it must be complied with sincerity and honesty. It must be observed to prevent one party from taking unfair advantage over the other. Non-compliance by the party with this legitimate obligation after receiving the benefits of a contract would constitute unjust enrichment on his part. Good faith. Basically kasi kapag nag-comply ka with in good faith, tapos yung isang party nag-comply in bad faith, yun yung opposite niya. Yan yung dalawa, maririnig yung parati yan. Pag nag-comply ka in good faith, you will be considered as the innocent party. Bakit? Kasi nag-comply ka with sincerity and honesty, ginawa mo yung tama. Ginawa mo yung tama. Yun yung basically meaning ng good faith eh. Ginawa mo yung tama, ginawa mo to properly. Pag nag-commit ka in bad faith, ibig sabihin, may negligence ka, may fault ka, hindi mo properly ginawa, may malice, may malicious intent, parang ganun, bad faith yun. Kapag nag-comply ka in bad faith, Diyos ko, problema yan. Bakit yan problema? Kasi mawawalan ka ng mga karapatan, mawawalan ka ng mga remedies, and pwede kang magkaroon ng liability. Kaya, take note, in all your doings, always comply with good faith. Kasi, good faith, in many instances, can be a valid defense. Oo, mapoprotektahan mo siya, ginawa ko naman yan properly eh. Bakit mo kinaano? Yan hindi niya ginawa. Ginawa niya in bad faith yan, sa'yo may kasalanan. Ako, ginawa ko ng maayos yung trabaho ko. Yung pakita ka ebidensya na nag-comply ka in good faith. Yun, ma-absuelto ka, basically. Now, let's go to Article 1160. So, ang natin isa, laws, contract. Now, let's go to quasi-contract. Article 1160 provides that obligations that is derived from quasi-contracts shall be subject to the provisions of Title 1 of Chapter 1, Title 17 of this book, which is the Book 4 of the Civil Code. So sa quasi-contract, gaya na sabi natin kanina, yung quasi basically, ang simpleng niyan, semi or partly. So in this case, semi-contract siya. So hindi siya full contract, sir? Oo, semi-contract siya. Bakit? Sabi dito, quasi, para matapos na tayo agad before 10:30, so wala nang recitation, so chill na kayo. So, Article 1160 treats of obligations arising from quasi-contracts or contracts implied in law. So, anong definition? According to Article 2142, quasi-contract is that juridical relation resulting from lawful, voluntary, and unilateral acts by virtue of which the parties become bound to each other to the end that no one will be unjustly enriched or benefited at the expense of another. Ano meaning yan? Excuse me po. Yung pinag-usapan natin kanina, yung before, is the proper contract. Ito, semi-contract lang siya. Bakit? Kasi sa proper contract, there is a meeting of minds between the parties na before sila magpasok sa isang kontrata, nagkaroon na sila ng agreement na kung ano yung maggagawin nila. And kung yung anong agreement nila, ikokontrata nila. Pagdating dito sa quasi-contract, wala silang agreement beforehand. Oo, wala silang civil relationship, wala silang contractual relationship at the first place. Pero due to an event that occurred, nagkaroon sila ng contractual relationship because of an event na nangyari. Yun yung difference ni contract kay quasi-contract. Si quasi-contract, beforehand, nagkaroon na ng meeting of minds between the parties. Nagkaroon na sila ng agreement. Napapasok sila sa kontrata. Pagdating kay quasi-contract, walang ganun. Wala silang agreement beforehand. Sadyang may nangyaring event na because of that event, it gave rise to a contractual relationship between the parties. So after nangyari ng event na yun, may contractual relationship na sila. Yun yung main difference ni contract kay quasi-contract. So yun, may dalawa tayong klase ng quasi-contract. Negotiorium gestio and solutio indebiti. So ito, anong sabi kay negotiorium gestio? 2144 provides that negotiorium gestio is the voluntary management of the property or affairs of another without the knowledge or consent of the latter. So, an example niyan. Ito, may example dito para mas mapadali na. Si X pumunta ng Baguio. Bumili ng melon. Went to Baguio with his family without leaving somebody to look after his house in Manila. So habang nasa Baguio si X at ang kanyang pamilya, nagkaroon ng sunog malapit sa bahay ni X. Ngayon, may sunog. Ngayong itong si Y, yung kapitbahay ni X, pumunta sa bahay ni X para iligtas ito mula sa sunog. Ngayon, in doing that, itong si Y nag-incur ng expenses. So yun yung situation natin. Si X pumunta ng Baguio with his family, walang iniwan o walang sinabihan na pakitingin or pakibantay ng bahay ko. Ngayon itong si Y, mabait. Nakita may sunog malapit sa bahay ni X, sinubukang iligtas and successfully nailigtas yung bahay ni X. And in connection with that, si Y nag-incur ng damages, nag-incur ng expenses, I mean. Ano mga expenses yan? Probably fire extinguisher, probably gasto sa tubig, expenses yun. Ngayon, anong mangyayari? Or i-analyze natin yung situation. Ito ng chat. Wait lang, may reply lang kay Ma'am Sat. Okay, may reply lang ako. Anyways, yun, i-analyze natin yung example. So, kung mapapansin nyo, sabi dito, walang iniwan si X, walang sinabihan si X para bantayan yung bahay niya. Pero because of an event, which is the fire that broke near the house of X, because of that event, and niligtas ni Y yung bahay ni X, nagkaroon sila ng contractual relationship. Di ba? Di ba beforehand, wala silang hindi kinontrata ni X si Y para bantayan yung bahay niya. Walang kontrata doon. So, walang previous agreement. But because of that event that arise, yung pagligtas ni Y sa bahay ni X, because of that event, a contractual relationship between the two arise. Kung saan, si X, nag-benefit. Nag-benefit siya, nailigtas ang bahay niya. Pero si Y, sa pagliligtas ng bahay ni X, nag-incur ng expenses. Nag-incur siya ng expenses. So, ang sabi ni quasi-contract, because of that, hindi pwedeng yung isang party will unjustly benefit himself, unjustly enrich himself at the expense of another. Hindi pwedeng si X magbe-benefit unjustly, tapos si Y, siya yung wala siyang marireceive, nagkaroon lang ng expense on his part. So sabi ni quasi-contract, sabi ni 2142, wag ganun. Hindi naman pwede. So with that, kailangan i-compensate ni X si Y for the expenses incurred by Y in trying to save the house of X. Yun yung pinopoint out ni negotiorium gestio under the quasi-contract. Hindi pwedeng chill-chill lang si X. Unjustly benefited siya Nailigtas ang bahay niya tapos hayaan niya lang na si Y na nag-incur ng expenses. Hindi pwede ganun. Kailangang i-compensate ni X si Y. Kailangan i-compensate ni X si Y para quit sila. That no one shall unjustly benefit, that no one shall unjustly enrich themselves at the expense of another. Bawal yun, kapatid. Yun kay negotiorium gestio under the quasi-contract. Now, let's go to the solution indemnity. Sa solution indemnity, ang sabi dito, this is the juridical relation which is created when something is received when there is no right to demand it and it was unduly delivered through mistake. So, ang requisites niya dalawa. There is no right to receive the thing delivered and the thing was delivered through mistake. Ano magandang example yan? Shopee. Shopee. Yung Shopee natin. Kung sabihin ko, tapusin ko mata bago ko reply si Ma'am Sat. So yung sa Shopee. Di ba? May mga instances kasi na sa maling bahay na di-deliver yung package mo. Sa maling bahay na di-deliver yung package mo. So in that case, nagkaroon ng it was delivered through mistake and yung kapitbahay mo does not have the right to receive that thing delivered. So na-follow yung requisite. So ano mangyayari niyan? Yung kapitbahay mo is now required to return the thing. To return the thing delivered. Either isauli niya sa courier or ibigay niya lang sa'yo. Kasi walang karapatan si kapitbahay ma-receive yan eh. So, analyze natin. Meron ba silang agreement beforehand? Wala, di ba? Wala. Pero because of that event that happened, yung package delivered through mistake sa kapitbahay mo. Because of that event, a contractual relation now arises. Kung saan itong si kapitbahay mo, may obligation na siya na isauli yung na-deliver sa kanya mistakenly. O yun, di ba? Wala silang walang kontrata o walang agreement beforehand. Pero because of that event, na may yung package mo na-deliver through mistake, may obligation na nag-arise. Mayroon ng contractual obligation. Na kung saan itong kapitbahay mo, required nang isauli yung natanggap niya through a mistake. O yun, solutio indebiti. So yun, quasi-contract. O kita nyo, di ba? Difference ni contract kay quasi-contract. Kay contract, merong agreements, may meeting of minds beforehand. Pagdating kay quasi-contract, wala eh. Pero nagkaroon lang ng contractual relationship because an event has happened. Negotiorium gestio, solutio indebiti. Yun kay quasi-contract. Kaya ang tawag sa kanya, quasi, semi lang. Hindi siya full contract. Now let's go to Article 1161. Article 1161 provides that civil obligation arising from criminal offenses shall be governed by the penal laws subject to the provisions of Article 2177 and of the pertinent provisions of Chapter 2, Preliminary Title on Human Relation and Title 18 of this book regulating damages. Now, crimes. Dito sa Pilipinas, mayroon tayong mga penal laws. Yung primary is the Revised Penal Code. Diyan na yun. Nandun yung mga homicide, arson, murder. Nandun yan. And meron din tayong tinatawag na Special Penal Laws. Meaning, hindi sila included sa Revised Penal Law. Ano mga sample ng Special Penal Law? Yung anti-drugs, illegal possession of firearms, yan. Hindi yan sila included. Mga special penal laws yan sila. Now, yung legal system dito sa Pilipinas, take note of this. Pinaparusahan ka lang if there's a law that prohibits it. Pinaparusahan ka lang if there's a law prohibits it. Kapag walang law na nagbabawal dyan, hindi ka pwedeng parusahan. Ganun lang kasimple yun. Ganon yung legal system dito sa Pilipinas. Paparusahan ka lang if may batas na nagpaparusa para sa act na yon. If walang batas na nagpaparusa sa act na yon, wala kang pagbabayaran. Ngayon, civil liability arising from crimes. Article 1161 deals with civil liability for damages arising from crimes. So, oftentimes, the commission of a crime causes not only moral evil but also material damages. From this principle, the rule has been established that every person criminally liable for an act of omission is also civilly liable as provided in Article 100 of the Revised Penal Code. Now take note, the general rule is, kapag nag-commit ka ng crime, you will not only receive criminal liability but also civil liability. That's the general rule. O yun na, general rule. So may exception yan, sir. Oo, may exception. Ano yun? Usually kasi may mga crimes kasi na kapag nakocommit mo, wala kang nakokos na damages. So kapag wala kang nakokos na damages, wala kang civil liability. Yun ang isipin nyo. So yun, ang general rule. Kapag may nakommit kang crime, hindi lang criminal liability ang meron ka. For example, baka pagbayaran mo ng fines or makukulong ka, ganun. Meron ding civil liability imposed with that. Kung saan, basically, dahil sa crime na nakomit mo, may damages kang na-incur. May damages kang na-incur. So, pag may damages ka na-incur, may civil liability ka. That's the general rule. Ang exception ulit, may mga crimes na nakomit ka kung saan wala kang damages na cause, di ba? Wala kang damages na cause, I mean. So, since wala kang damages na cause, wala kang civil liability. Ganun lang yun. O in crimes, gaya dito, in crimes however which cause no material damages, ito mga example, contempt of court, yung nagpasaway ka sa korte, hindi ka na nahimik, parang ganon, insults to person in authority, nag-trash talk ka sa police, gambling, violations of traffic regulations, beating the red light, may nakos ka bang damages while beating the red light? Wala, di ba? Nilusutan mo lang yung intersection, wala ka nakos sa damages, so that is a crime. Pero may nakos ka bang material damages? Wala. So wala kang civil liability. Pero meron ka pa ring tawag dito, criminal liability. Now, scope of civil liability, the extent of the civil liability for damages arising from crimes is governed by the revised penal code and the civil law. The civil liability includes restitution, reparation for damages, cost, indemnification for consequential damages. So yun yung pino-point out dito sa pang-apat na source ng tawag dito, ng obligation. Kapag nag-commit ka ng crime and nag-cause ka ng material damages, nag-cause ka ng harm, nag-cause ka ng injury, nag-cause ka ng loss, di ba? Pag nangyari yon, you are also liable with for civil liability. Now, since naging liable ka na sa civil liability, you now meron ka na ngayong obligation to compensate for that, para magbayad sa material damages na na-cause mo. Yun na yung obligation doon. Kapag meron kang civil liability na kailangang i-comply, yun na yung obligation doon. Kaya sinasabi dito, kaya na yung crime naging fourth source of obligation. Because kapag nag-commit ka ng crime and there's a material damages, merong civil liability, and yung civil liability na yun is the obligation. Yun. Now let's go to the last article, 1162. Obligations derived from quasi-delict shall be governed by the provisions of Chapter 2, Title 17 of this book and by special laws. Ito na. Quasi-delict ulit. Quasi-delict. Ibig sabihin, semi yung pagkano niya. Kasi ang delict, crime yan. So, since ito quasi-delict, semi-crime lang. Bakit semi-crime, sir? Kasi dito, civil liability lang ang kailangan mong bayaran. Walang criminal liability. Ganun lang. Kaya sa quasi. Yes, nag-cause ka ng damages, nag-cause ka ng harm, nag-cause ka ng injury, nag-cause ka ng loss. Pero wala kang criminal liability. Civil lang. So, since civil lang, quasi lang. Quasi siya. Semi. So, the above provision states of obligation arising from quasi-delict or torts. Tawag sa kanya, torts, another term. So, ang sabi ni 2176, a quasi-delict is an act or omission. O, kita nyo, may omission din dito. By a person, also known as a tortfeasor, which causes damages to another person or to another in his person, ibig sabihin sa tao mismo, sa property niya, bahay niya, kotse, property that he owns, or the rights, violating the legal right, di ba? The legal right of the person. Meaning, ang example niyan, right to vote. Prevent mo yung tao na magboto, di ba? Parang ganun. Or rights, giving rise to an obligation to pay for the damage done. There being fault or negligence, but there is no pre-existing contractual relation between the parties. O yun, quasi. Yeah? As you can see here. Nandito ulit no contractual, no pre-existing contractual relation between the party. Di ba napag-usapan natin sa quasi-contract? At beforehand, wala silang agreement, wala silang kontrata. Pero because of an event happening, it gave rise to an obligation. Same analogy pagdating kay quasi-delict. Wala silang pre-existing contractual relationship. Pero because of an event, in this case, that event has caused harm, damages. has caused harm, loss, or injury to another person, which caused damages. Nagkaroon na ng contractual relationship between the two, for which yung tortfeasor, yung person na nag-commit ng act or omission, that person now has the civil liability, now has the obligation to compensate the aggrieved party. As you can see, ang difference ni quasi-contract kay quasi-delict, si quasi-delict, it talks about unjust enrichment. Ibig sabihin, yung isang tao nag-benefit at the expense of another, so kailangan i-compensate. Dito naman, ang nangyari, nagkaroon ng harm. Nag-cause ng harm, nag-cause ng loss, nag-cause ng injury. And because of that, it caused material damages. It caused damages. And since it caused damages, kailangan magbayad ng civil liability, mag-compensate. Indemnification, tawag dyan. So ito, requisites ng quasi-delict. Before a person can be held liable for quasi-delict, may requisites tayo. Una, there must be an act or omission. Of course, because that act or omission gave, yan yung event na nangyari. And that act or omission must be performed with fault. Kasalanan mo, with negligence. There's a neglect on your part. There's a neglect or damage on your part. And third, there must be, because of that, wait lang, tumatawag. Hello, sir, nasa klase ako. Sige. Nabasa ko na po yung chat. Sige. So, ano tayo? There must be an act or omission, there must be fault or negligence, and there must be, and because of that act or omission that was performed with fault or negligence, nag-cause siya ng damages. Nag-cause siya ng damages. And with that, there must be a direct relation or connection with the cause and effect between the act or omission and damage. Ano meaning yan? Causation dapat. Causation, hindi correlation. Meaning kapag nasiko ko to siya, tapos nabali ang ribs niya, yung cause ng pagkabali ng ribs niya is yung pagsiko ko sa kanya. Causation dapat, hindi correlation. And number 5, there's no pre-existing contractual relationship between the party, kaya nga sa quasi wala silang pre-existing contractual relationship. But because of an event happening, it gave rise to an obligation. In this case, yung event na yon is an act or omission that has caused damage to another person, whereby that act or omission was performed with fault or negligence. Yun si quasi-delict. Yun si quasi-delict. Ito, example, while playing softball with his friends, etong si X, nasira yung window glass ni Y, neighbor nila. The accident would not have happened had they played a little farther from the house of Y. From the house of Asman. From the house of Y. So, yung causation nito, yung pagtapon, di ba? Yung paglaro nila. Under obligation to pay damages, etc., etc. Ito, lastly, crime distinguished from quasi-delict. Ito, nasabi natin kanina, itong si crime, there's a criminal or malicious intent or criminal negligence. Yan lang tatandaan nyo kasi may mas in-depth discussion to sa pagdating sa criminal law sa law. Pero ito lang tatandaan nyo, may criminal or malicious intent pagdating sa crime. Pagdating kay quasi-delict, negligence lang or fault. Kay crime, criminal negligence. May difference yan sila. Pangalawa, in crime, the purpose is punishment, parusahan. While in quasi-delict, indemnification lang. Bayaran mo lang yung damages na na-cause mo. Civil liability lang. Pagdating kay crime, may criminal liability, and kapag nag-cause ka ng material damages, meron na rin kasamang civil liability. Pagdating kay kay quasi-delict, civil liability lang. Indemnify mo lang. Compensate mo lang yung damages na na-cause mo. Third, crimes affect public interest. While quasi-delict, between the private capacity lang. Private interest lang ng parties. In crime, there are gaya ng sabi to, there are generally two liabilities. Criminal and civil. Ulitin natin, nagkakaroon na ng civil kapag mayroong damages. Kay quasi-delict, civil liability lang. Criminal liability cannot be compromised or settled by the parties themselves kasi kailangan parusahan yan. While the civil liability for quasi-delict, pwede magkaroon ng compromise. Ibig sabihin, ikaw, meron kang civil liability sa neighbor mo. Di ba? Nasira yung glass, yung window glass niya. Pero yung neighbor mo, may utang pala sa'yo beforehand. May utang pala sa'yo. So pag may utang pala sa yung neighbor mo, so anong gagawin? Pwede mo silang i-compromise. Mag-quits na lang kayong dalawa. So yun, criminal liability, hindi mo siya pwede compromise, pero civil liability, pwede. In crime, the guilt of the accused must be proven beyond reasonable doubt. Ito ilang beses na narinig. Basically, itong beyond reasonable doubt, kung i-quantify natin to siya, it's 99.9% na sure kayong, or 99.9% certainty na sure kayo na siya yung may kasalanan. Yan yung pagdating sa crime. Pagdating sa quasi-delict, the fault or negligence of the defendant need only to be proven by preponderance of evidence. So, superior or greater weight, basically, at least 51% sure kayo na siya yung may kasalanan. So, ganun pag i-quantify natin sila. Beyond reasonable doubt, 99.9%. At least, pagdating kay civil liabilities, preponderance of evidence lang yan, at least 51% kasi superior or greater weight of evidence. So, yan yung last part ng discussion natin for the general provisions, chapter 1 of obligation. So, next topic natin, chapter 2, nature and effects of obligation. So, before tayo mag-end,